Hey everyone, welcome to the channel Decode the Law. As I told you in my earlier video that I will tell you all the techniques to learn the section properly, and not only that, also tell you how to remember the law. And law is all about application. If you are able to remember the law properly, then you will know automatically that how to make application of the law. So in this video, I have taken the reference of chapter 18 of the Code of Criminal Procedure. Chapter 18 deals with the trial before the Code of Session, and this chapter comprises of total 13 sections from section 225 to 237. So watch the video till the end and I will tell you all the techniques to remember the law properly. I can guarantee you that you will remember the law properly after watching this video. So let's dive in. Before going into chapter 18, we need to know three sections. Number 1, 209, 199 subsection 2 and 193. So 209 enumerates provision relating to committal proceedings. 199 subsection 2 enumerates the provisions relating to defamation cases of constitutional functionaries. And 193 creating an embargo on the way of the session court to take direct cognizance. As we know that court of session cannot directly take cognizance of any offence exclusively triable by such court according to the first schedule. So, session court has no power to take direct cognizance of an offence. 209 states that commitment of cases to the court of session when offence is triable exclusively by it. It means that when in a case instituted on a police report, so police report में case institute हो रहा है और otherwise than on police report, otherwise मतलब complaint cases, the accused appears or is brought before the magistrate and it appears to the magistrate that the offence is triable exclusively by the court of session, then he shall commit the case to the court of session. Commit the case to the court of session मतलब मैजिस्ट्रेट वो केस को सेशन कोर्ट के पास भेज दे रहा है. ठीक है. Then let's come to section 225. 225 is enumerating the provision relating to trial to be conducted by the prosecutor. In every trial before the court of session, the prosecution shall be conducted by the public prosecutor. So, public prosecutor will conduct the case. And after section 225, 226 will come into the picture. That is opening of the case. Opening of the prosecution case, how the prosecution case will open. If you ask this question, then you have to say that when the accused appears or is brought before the court of session or in pursuance of the commitment of the case under the provision of section 209. 209, as I told you, that is a committal proceedings. So then the court or then the prosecution shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to have guilt of the accused. After that, two situations may arise. Number 1, that is 227 or 228. 227 is enumerating the provision relating to discharge. So after considering all the material evidences and after considering the record, the magistrate is of the opinion that there is no sufficient reason to proceed against that particular accused, then magistrate giving reasoned order can discharge the accused person. And then section 228. What is 228? 228 states framing of charges, and 228 comprises of two subsections, subsection 1 and subsection 2. Section 1 states about that after considering and hearing the aforesaid opinion of the judges that there is a ground to presume that accused had committed the crime. यहाँ पे जज को लगता है कि वो एक्यूज्ड ही क्राइम किया है. जज इज ऑफ द ओपिनियन, मतलब उनको लग रहा है कि एक्यूज्ड व्यक्ति ने ही कमिट किया है, तो तब वो चार्ज फ्रेम करने के लिए प्रोसीड करेंगे. And this provision can be divided into two parts. Number 1, that is clause A, and second one is clause B. So clause A states about where it is not exclusively triable by the court of session, and clause B exclusively triable by the court of session. So where judge who is of the opinion that this case is not exclusively triable by the court of session, then after framing the charge, the judge may forward the case to the chief judicial magistrate or any other judicial magistrate of the first class and direct the accused to be appear before that particular कोर्ट. सो एक्यूज व्यक्ति को डायरेक्ट किया जाएगा कि आप वहां पर जाइए, वहां पर आपका ट्रायल होगा. ठीक है. देन दिस ट्रायल विल बी कंडक्टेड एज केसेस इंस्टीट्यूटेड ऑन पुलिस रिपोर्ट. वारंट केस में जैसा ट्रायल होता है वैसा ये ट्रायल को प्रोसीड मतलब किया जाएगा. Then comes to clause B. So where magistrate is of the opinion that the case is exclusively triable by the court of session, then he shall frame the charge in writing and proceed against the accused. And subsection 2 is all about that when the judge frames any charge under clause B subsection 1, the charge shall be read and explained to the accused, and the accused shall be asked whether he pleads guilty of the offense charged or claims to be tried. So accused को जज के द्वारा पूछा जाएगा कि आप गिल्टी मानते हो या नहीं. और यहाँ पे ये भी बोला जा सकता है कि डू यू प्लीड्स गिल्टी और नॉट, or claims to be tried. The term claims to be tried that has been used in section 228 subsection 2, which means that accused is saying that I haven't committed any offense, I want to proceed with the trial. This is the thing. And then section 229 states conviction on plea of guilty. Suppose if accused says that yes, I have committed the offense. The accused is saying that yes, I have committed the crime. Then after 229, 236 can happen. 236 can happen means what? It means that section 236 enumerates the provisions relating to previous conviction. Suppose after explaining the charges that has been brought against him, explained by the magistrate to the accused, then if the accused pleads guilty, then after section 229, 236 will come into the picture. 236 is something which actually enumerates the provisions relating to previous conviction. In a case where a previous conviction is charged under the provision of section 211 subsection 7 and the accused does not admit that he has been previously convicted as alleged in the charge, then the judge may, after his conviction, the said accused under section 229 and 235 take evidence in respect of the alleged previous conviction and shall record the finding thereon, and the evidence relating to the same will be taken. Then and if suppose 229, in case of 229 the accused doesn't plead guilty, what will be the situation? Then it is 230. 230 is enumerating the provisions relating to date for prosecution evidence. Date for prosecution evidence दिया जाएगा. Or if the accused refuses to plead guilty or does not plead guilty or claims to be tried, he is not convicted under section 229, then the judge shall fix a date for the examination of the witnesses, witness को examination करने के लिए, और application of the prosecution issue any process for compelling the attendance of any witness or for the production of document or other thing. Then after section 230, 231 will come into the picture. So 231 enumerates the provisions relating to evidence of prosecution. Then prosecution party will enter into the evidence. So on the date so fixed by the judge, at that day prosecution party will produce the evidence in their support. And then judge in his discretion will permit the cross-examination of the witnesses, and the witness have been examined or recall any witness for further cross-examination. And then 313 subsection 1 clause B will come into the picture. So what is section 313 clause B of the Code of Criminal Procedure? Section 313 actually enumerates the provisions relating to story of the accused. I am not going into the detail. 313, it basically states that after all the evidences is being produced by the prosecution, then judge will give an opportunity to the accused person that जो भी incriminating circumstances, मतलब जो भी एलिगेशन वो एक्यूज के खिलाफ अराइज हुआ है, उसके सफाई देने के लिए जो प्रोविजन है, that has been mentioned in section 313 1b, and we will discuss this provision later on in a greater detail, because this provision is very much powerful in itself and it's quite amazing, and it will actually amaze you when we will discuss. Okay, next, after the prosecution evidence, then section 232 will be applicable. So suppose after giving the prosecution evidence, this is the situation that there is nothing as incriminatory which is actually making the accused guilty, so there is no sufficient reason to hold the accused liable. After taking evidence for the prosecution and examination of the witnesses, the magistrate can acquit the accused person after recording the reason and after giving a reasoned order. Okay, and then section 233 states about the evidence for defense, and defense party will enter into the evidence from this stage. Where the prosecution is not acquitted, where the prosecution is not acquitted means acquittal can happen in section 232, right? So in this case, suppose acquittal is not happening, then section 233 will come into the picture. It states that where the accused is not acquitted under the provision of section 233, he shall be called upon to enter on his defense and adduce evidences in his support. And then it is section 234. 234 enumerates the provisions relating to argument. It is the argument stage. डिफेंस का जो विटनेस है उन लोगों का एग्जामिनेशन कंप्लीट हो जाने के बाद prosecution shall sum up his case and the accused and his pleader will be entitled to reply. मतलब डिफेंस पार्टी रिप्लाई करेगा जो भी प्रोसिक्यूशन पार्टी ने एविडेंस दिया है accused व्यक्ति के खिलाफ. For example, suppose there is an evidence which is showing that prosecution, the evidence of the prosecution party, that accused person was present at that particular place where the crime has happened, and defense party can adduce evidence that at that point of time accused was not present there, he was at somewhere else. Okay, so these are the evidences that can be adduced by the defense party. And then section 235 and 235 in enumerating the provisions relating to either acquittal or conviction. It means suppose after argument, after hearing both the parties, the magistrate is of the opinion that accused has not done anything, accused is innocent, then he will be acquitted. And after the all the after examination of the witness and all the documents on record, then judge is of the opinion that accused is the main culprit, then he will award conviction. And then subsection 1 of section 235 states about that after hearing arguments and points of law, the judge shall give the judgment in the case, and if the accused is convicted, then judge shall proceed in accordance with the provision of section 360 enumerates the provisions relating to provision of the offenders on good conduct and after the admonition and all, so then he can be released. But the criteria of section 360 must be complied with. And then section 236 will come into the picture. 236 states about the previous conviction, and 211 subsection 1 specially enumerates the provisions relating to enhanced punishment. Uske baad section 237 read with 199. So 237 enumerates the provisions that suppose there is a situation, it is a case of defamation cases of constitutional functionaries, then warrant case trial that is instituted otherwise than on police report, these procedures will be followed. That has been mentioned in chapter 19 and section 244 to 247 of the Code of Criminal Procedure. This was all regarding chapter 18 of the Code of Criminal Procedures. Very important topic for the examination purpose and for any competitive exam like judiciary service and all. Now friends, you will ask that what are the tricks or technique? Here is the tricks and techniques that I will tell you now, because only after having a clear knowledge
of the provision, then only you will be able to apply your technique. So what is it? The flowchart that you will be able to see on the screen, and I know there is nothing in this flowchart, because and you are thinking that there what is in it. This is a very simple, nothing extraordinary in it, right? So let me tell you, section 125 to 237 of chapter 18 of the Code of Criminal Procedure actually conducting the entire trial of the code, right? So these are the sections on the basis of which will be conducted. So now let me ask you, till section 225 to 237, how many sections are there? Are total 13 sections. So how many sections? So there are total 13 sections. So is it humanly possible to remember 13 sections one after the another in a scheduled manner? Ask yourself. You will be never be able to remember 13 sections one after the another if you don't apply any kind of techniques to remember these things. So what is the thing? The thing is that if you make a flowchart like this, that you don't need to put a lot of words in it, just the keywords, and just by looking at the keyword you will be able to remember all the provisions, like sessions trial mentioned in chapter 18. Opening section is 225 and closing section is 237. Okay, and before going into chapter 18, we have to know 209, 199 subsection 2 and 193 of the Code of Criminal Procedure, which is an embargo, because we all know the session code has no power to take direct cognizance of an offense. You will say, what is big deal in it? Okay, now let me tell you, if you are having any commentaries on CrPC, then just go to the chapter where the trial before the session code has been explained and count the pages, that it will be like at least 10 to 12 pages, right? Now you tell me, is it humanly possible to remember all those 10 pages and write the answer in the examination? The answer is no. Because in order to write the answer, especially in procedural law, you just need to know what are the sections and what are the keywords of those sections. So if you remember like this, section 225 PP means public prosecution will conduct the case. Then section 226, opening of the case for prosecution. Then after section 226, two things can happen, 227 and 228. 227 is recent order and discharge, and if recent order or discharge doesn't happen, then it is 228. This is charge frame or framing of charge. And this section have two clause 1, clause B. So clause A states about not exclusively triable by the Code of Session, and clause B about exclusively triable by the Code of Session, right? So finding out that yes, it is exclusively triable by the Court of Session, then court will frame the charge, and if it is not exclusively triable by the Court of Session, he will frame the charge and will send the matter to the CJM or any first class magistrate and direct the accused to be present before that particular court. After framing the charge, it is section 229. Judge will ask under subsection 2 of section 228 that do you plead guilty? If accused says that yes, I plead guilty, that yes, he has committed the crime, he will on his discretion convict that particular person. Okay, then directly imprisonment will be happen. Then if that particular person is convicted by the magistrate, then this will come directly in section 236. 236 states about the previous conviction. उसके बाद आता है next stage, that is stage number 6. Stage number 6, that is section 230. 230 states about the date for prosecution evidence. And then step number 7, that is 231. 231, prosecution party will give evidence. This section is read with section 313 subsection 1 clause B. This states about story of accused. Okay, and then two situations may arise. Number 1, 232 or 233. If on the evidence the magistrate is of the opinion that he has not committed any offense, he is innocent, then magistrate will acquit. Okay, then if acquittal doesn't happen, case will reach at section 233. 233 states about what? States about defense evidence. Then defense party will enter into its evidence. And then comes to argument stage. Argument stage. Argument stage means what? The evidences, जो सारा evidences prosecution party ने दिया है उसको वो reply करेगा, मतलब accused उसके favor में evidence देगा. उसके बाद 235 is about either or. Either or means either conviction or acquittal. Okay, either conviction or acquittal मतलब अगर evidence के बाद the magistrate is of the opinion that he has committed the offense, then he will be convicted. Okay, and if the magistrate is of the opinion that no, he hasn't done anything, he is innocent, then he will be acquitted. बेकसूर खलास किया जाएगा. ठीक है. Then magistrate will proceed under section 360 into probation on good conduct or admonition, and then section 236, that is the previous conviction. Then magistrate will take the evidence of previous conviction. पहले भी वो अरेस्ट हो चुका है, क्या जेल में रहा है, ऐसा मतलब एविडेंस लेगा. मुझे माफ़ कर दीजिएगा, मेरा हिंदी थोड़ा ठीक नहीं है, बट मैं कोशिश कर रही हूँ बोलने के लिए. एंड नेक्स्ट दिस सेक्शन 236 रीड विथ सेक्शन 211 of CrPC and is subsection 7. Subsection 7 enumerates the provisions relating to enhanced punishment. Okay, and then next come to section 237. 237 read with 199 of the CrPC, that is the defamation case of higher dignitaries. Here in this case, if it is a case coming under section 199, then warrant case procedure will be followed, that has been mentioned in chapter 19 from section 244 to 247. Now you tell me, is it not easy for you to understand or easy for you to remember the thing? Just have the screenshot of my notes, just go through and then tell me or then give me feedback what you have to say. And let me tell you one thing, that if you are having any kind of difficulties in understanding or if you are having any kind of suggestion, then please don't hesitate to share your valuable feedbacks with me. I will definitely appreciate your feedback. Please go through these notes. If you have any kind of difficulties in understanding, let me know. I will promise you that I will make another video on this particular topic. This is me, Advocate Papia, signing out. And I will see you on the other side with an interesting topic, with my tricks, my techniques, with an amazing way. Thank you so much for watching this video till the end.